Bismillahirrahmanirrahim. We are again here to present before the viewers and listeners the chapter 1 of international law. Chapter 1 starts with origin and history of international law. Question 1: what is international law? Explain the scope and object of international law. What is difference between general and regional rule? Also discuss the origins and development of international law. This question had been repeated in CSS exam in 2001, 2013, 2016 and 2019. What is international law or nature of international law? Basically and traditionally, international law is seen to be a body of rules that regulate the relations between states. It was a traditional definition, but with the passage of time, the definition of international law was expanded, and nowadays, international law is a set of rules, is a set of rule, regulations, and convention treaties that regulate relations between states, multinational companies, international national organizations, INGOs, and even that regulate the relation and affairs of individual. After 9/11, the terrorists, the so-called terrorists who targeted humanity and the human capital and the infrastructure at large, and declared as international terrorists under the UNO, also the subject and object of international law. Uh, there are internationally recognized professors and statesmen who have submitted the definition of international law. The profound, the most famous are Professor Charles Hyde, Professor Oppenheim. The definition of Oppenheim is also a very classic definition. According to Oppenheim, international law is a set of customary and convention rules and principles which the civilized states consider binding on them in their relation with each other. What is the scope of international law? As we already stated that traditionally it was considered that the international law regulates only the relations between states and limited to the states only. But with the passage of time, the scope of international law has been expanded from states to multinational corporations, companies, INGOs, NGOs, individuals as well. Main object of international law, primarily the object of international law was to regulate uh, the affairs between the main subject, but with the passage of time, in addition to just a treatment for the states, the modern law of nations also aims to securing justice for human beings. The justice is a primary purpose of the law of nation, emphasize its kinship to state law. Kinship means it has a relation to state law. International law basically is executed through state law. General and regional rules of international law. What is difference between general and regional rules? Rules are those principles of international law which have universal application, that have reach to all the subjects and all the states under the umbrella of UNO. But the regional rules of international law which deals with a specific part of universe, like a certain continent or a country. Uh, um, uh, in Latin America, certain rules exist regulating the affairs, but in other countries that are not, such as rules of asylum are different in different regions. Therefore, there are two types of rules of international law, such as general rules and regional rules. Origin and development of international law. There are different theories about the origin and development of international law, but during the 16th and 18th century, there is a written history of international law. But according to historians, the international law was existing in Roman Empire, in Persian Empire as well, and even in Islamic country, the principle of international law were existing because the exchange of ambassadors, the exchange of treaties, the treatment of prisoners of wars was established practice, in the modern days those practices has also been recognized, and the same is being practiced uh, since then. Even many centuries before the dawn of Christianity, the certain laws and usages of war, the treaties and the immunities of ambassadors also to be found in ancient Egypt and India. This is also in Naswam of concise history of the law of nations, revised edition, page number 1, and edition was revised in 1954. The examples of historical cases of sources to arbitration and mediation in ancient China and the early Islamic world are present. Although it would be wrong to regard these early instances as serious contribution towards the evolution of modern system of international law. But according to modern professors and historians and writers of international law, uh, the rules were not only applicable in the relations in interstate of the sovereign Greek cities, but as between them and neighboring states. It means the principle and regulations and rules of international law were present in ancient Greek states, that were also called the sovereign Greek states. This was also recognized by Professor J.G. Starr. Current status of international law. Presently, the international law has been developed and evolved over the years and over the centuries. And since the 16th centuries, the law is evolving, but the main development was made during the 18th century and thereafter. Presently, the international law is recognized universally and it has a force, but not a force such as have with common law and the local laws, but it has a binding in a sense of opinions of the state and the policies, and the subjects are forced to implement the law through sanctions, through restrictions, through regulation of relations, etc. Uh, at the end, international law, also called law of nations, from a practical point of primarily is a system regulating the rights and duties of states inter se. It also regulates the functioning of international legal personalities, that is, international organizations, multinational companies, organizations. It also regulates the rights and duties of certain individuals, such as the servants of the UNO and other organizations. International law also takes cognizance to punish the individuals committing the crime of genocide, race, destruction, crime against peace, and crimes against humanity. International law provides a framework within which the international intercourse and international relations are conducted between the states, and it also provides legal system for war and peace. This is the short brief about the first subject, that is the scope of international law, its development, its origin, and its other parameters up to date. Thank you very much.